Unification and coordination of maritime jurisdiction, providing a judicial guarantee for international trade and marine transport. Maritime jurisdiction plays an important role in international trade and marine transport. It involves special kind of rules that vary among different countries and legal systems. Thus, in international maritime jurisdiction, the coordination and settlement of jurisdictional conflict are vital for the uniformity of international maritime law. This study provides a comparative analysis of maritime jurisdiction in international trade and marine transport. First, it introduces the concept, category, and legal characteristic of maritime jurisdiction based on historical source. Then, we conduct a comparative analysis of the civil law system, common law system, international convention, and Chinese maritime jurisdiction provision, focusing on their differences and the existing legal problem. Among other suggestions for the improvement of the rules of maritime jurisdiction, this study proposes the unification and coordination of maritime jurisdiction, which could impact international trade and marine transport. In international trade and marine transport, many disputes require resolution through maritime litigation. Jurisdiction is the basis upon which a court accepts a case. It is a precondition for judicial power and assures the resolution of dispute. The procedural rules for judicial proceeding are determined by civil jurisdiction in accordance with the principle of the connecting factors of the case. Although maritime jurisdiction falls under the general category of civil litigation, it has certain specialized underpinning features. Generally, the spatial characteristics of maritime court are incompatible with those of local court. Countries with spatial jurisdiction for maritime cases may lose the objective of setting up separate courts to consider maritime cases if they do not clearly stipulate the scope of acceptance. However, some countries do not have separate maritime courts but establish domestic courts with certain exclusive characteristics related to maritime jurisdiction. Jurisdiction at the Maritime Frontier. Harvard Law Review 14, number 1 until 26. Nevertheless, there are instances where the rules of general jurisdiction apply to maritime dispute and allow parties to conclude valid agreement with maritime court or special court. These courts have the right to refer cases to other courts in exceptional circumstances. For countries that conduct maritime litigation and general civil litigation separately, the spatial jurisdiction of the designated maritime court needs to be confirmed first. Domestic maritime jurisdiction refers to the division and limitation of the authority of maritime cases, a first instance by maritime court at different or the same levels in a country. In the international maritime field, efforts have been made to unify maritime regulation. However, it remains difficult to coordinate conflict concerning maritime jurisdiction involving foreign players. Disputes concerning maritime jurisdiction among countries are real and pressing problems. Compared with domestic maritime jurisdiction involving foreign players is almost unregulated. To solve problems that arise in maritime jurisdiction involving foreign players, the appropriate first step is to focus on the law of procedure of a country with jurisdiction to establish which of its courts has the right to exercise jurisdiction. Therefore, maritime jurisdiction involving foreign players is exercised based on domestic maritime jurisdiction. The legitimacy of jurisdiction is a prerequisite for the court of various countries to exercise jurisdiction. If the relevant maritime award document cannot prove that they follow the internationally accepted jurisdictional rules, they will not be respected, recognized, and executed by other countries. This study focuses on the unification and coordination of maritime jurisdiction. Research methods include empirical approach, case analysis, and comparative research. By summarizing the civil law system, common law system, international convention, and Chinese maritime jurisdiction and judicial practice, the legal problem in the operation of maritime jurisdiction are identified to determine an efficient system of maritime jurisdiction. This is done to provide better judicial protection for international trade and marine transport. Maritime jurisdiction system of civil law countries. In the civil law system, nationality plays an important role in personal jurisdiction. For example, Article 14 and 15 of the Code of Civil Procedure of France provide that French courts have jurisdiction of a dispute involving their citizen. French court has jurisdiction as long as one of the litigants is French. This provision makes it possible for the parties to come under the jurisdiction of French court even when the dispute in the case is unrelated to French. Other civil law countries pay more attention to domicile as the connecting factor of jurisdiction than nationality. For example, in Germany, the court generally exercises jurisdiction based on the residence of the accused party. With the development of the equity theory, the single application of nationality or residence as a connecting factor for jurisdiction has been gradually eliminated. New rules are being developed to establish specific jurisdiction connection points, such as the place where the contract was performed, the place where the tort was committed, and the place where parties agreed to submit their dispute. The basis for the exercise of maritime jurisdiction in the civil law system mainly include the defendant resident or principal business office, the ship registration place, birthplace or flag state, place of signing the contract, the place of the performance of contract, the place of loading or unloading, the place of infringement, and the place of ship arrest. Additionally, civil law countries generally recognize the jurisdiction agreement signed by the parties. The court has no discretion to decide whether to apply the jurisdiction agreement of the parties. Therefore, it must be determined strictly following the legal provision of the agreement. For example, according to the Code of Civil Procedure of France, the validity of a jurisdiction agreement is as follows. Firstly, the jurisdiction clause must be in writing and must be clear and easy to read. Secondly, the jurisdiction clause must conform to the principle of full consent of the parties. Thirdly, the jurisdiction clause must clearly select the court. Fourthly, the jurisdiction clause must not be contrary to public order or manifestly unfair. If the jurisdiction clause meets this formal requirement, the court will simply review its content to ensure that it doesn't violate the most basic principles of fairness. Some European countries that follow the civil law system are part of the European Union, whose laws are regarded as a special mixture of international and domestic law. The maritime jurisdiction of the European Union has obvious characteristics of international jurisdiction and is different from the individual domestic maritime jurisdiction. The maritime jurisdiction of the European Union is a broad civil and commercial jurisdiction. European Union law should not be called international law, but supranational law because, in their opinion, the European Union has become a supranational organization beyond its member state, and the policy principles of its member state do not enjoy the status of the general legal principles of European Union law. The Court of Justice of the European Union, as a judicial organ, has certain inherent rights arising from its role. In international law, the function of the court is to state the law. Thank you.